Good morning, everyone. It's 11 o'clock on the 27th of April. I've started the webinar just to allow people to join, so I'm going to give people a moment just to join us. Okay, well, good morning, everyone. I hope you are well. It's great to see so many of you signing up for our webinars and also joining us live. Always fantastic to have that engagement. So thank you so much for supporting our webinars and what we're doing. So we are in April. This is April's webinar, and what we wanted to do today is talk about the Employment Tribunal process and what that looks like. Many of you who are joining us today may well have been to an employment tribunal. You may have claims that are currently going through within your own businesses, or it may be ones where actually you haven't had the fortune or misfortune of being in the employment tribunal and want to hear a little bit more about what the process looks like. And as you know, I like to bring you different voices and different people joining me on the webinars. So today, absolutely thrilled that my colleague Peter Olszewski is joining me today. And Peter, brilliant. Thank you so much for joining me. Good morning.
Good morning, Emma. Thank you.
Brilliant. So just a little bit about a bit of housekeeping and a bit about Boyce Turner. For those of you who don't know who we are a full service commercial law firm. We are based in the Thames Valley, but we look after clients all across the UK, across Europe, and also globally as well. In the employment team, we provide HR assistance, litigation assistance, which obviously is what we are talking about today, as well as business immigration services to help with recruitment and recruiting globally, as well as helping clients with their training and their training programs for managers, HR teams, and wider employee populations. So we are live today, and as always, this is an overview. So if anybody has any specific questions or specific issues or requires any help or assistance at all with tribunal claims, then please do get in touch with us. So who are we? Well, I'm Emma O'Connor. I'm a director in the employment team and also head up our training academy, where we provide bespoke, in-person, virtual and pre-recorded training for HR teams, managers and employee populations as well. And as I said, I'm joined by my colleague Peter, a senior associate in the team. Peter, introduce yourself and tell everybody what you do.
Yes, good morning, everybody. So as Emma said, I'm a senior associate in the team. I'm also a solicitor advocate, which means I've had additional training in advocacy, and it also gives me additional rights in different jurisdictions when advocating, which in short is representing clients at trials. I've been practicing for around 15 years now, and I've been a litigator for all of that time. And that includes acting in a real wide range of jurisdictions, to include the county courts, the high courts, tribunals, employment appeal tribunals, courts of appeal. And in short, that gives me a really good overall perspective of how the court system works, the civil procedure rules, the employment tribunal rules. And I've also had really good exposure to a really wide variety of cases, acting for both claimants and respondents, so I can see both people's views on a case. And most importantly for this webinar, it gives me a good insight to the do's and don'ts of employment tribunal litigation.
Absolutely, thank you. So we are in a safe pair of hands today when it comes to finding out more about the employment tribunal system and some of the pitfalls. Just before we get cracking, just wanted to tell you about some courses that we are running that is available to join. So if you are a business manager or in HR, what are you doing on the 10th of May? Well, hopefully you will be joining me for a mini masterclass where we are looking at how we can build that positive mindset. So how does our mindset as a leader, whether that be in HR or a business leader or a people leader, how does our mindset impact our teams, and how can we keep ourselves in that positive frame of mind. And so what are some of the tips and techniques? And I'm running that with Rosemary Ryan from Represent, who I ran the February webinar with. So a really great opportunity there for you to join, fully interactive, will be, but that one is a virtual one. So please do join and look at the invites to that. And then I'm super excited about the HR Masterclass 2023. If you are new to HR, if you want an HR refresher, if you've had a change of career and you've come to the wonderful world of HR and want to learn more, then this really is a 2-day whistle-stop tour of everything you need to know as an HR professional. And it's designed for HR. It is drafted for you. It's delivered by me over 2 days in person in a classroom style. If you want to find out more about the course or hear feedback about what others have said, then please do get in touch with me. So again, I'll be sending that out. And yeah, why should you attend? So quite simply because it's great. So yeah, please do join, and I'll be sending out the invite for that. So hope to see you in person in Reading for that as well. So last month, those of you who joined our webinar, I was doing a case law update webinar, and I talked about where we were in terms of the Employment Tribunal statistical landscape. Now, we do have reports that are published about where we are in terms of cases, what it's looking like. And I think that's always a useful place to start when we start talking about, tribunals and cases that are being brought. I mean, in essence, we are in a backlog situation. We've got cases that we know that are being listed for, 2024. Because quite simply, there is a backlog of claims that the tribunal are trying to get through. Interestingly, the number of single claims has increased. So we're looking at the statistics up until the end of October 2022, because that's when they're published and released to us. So the number of single claims has gone up, and that's where you've got one individual bringing one claim against their employer or former employer or the organisation for which they work for. We've seen a slight decrease in multiple claims. Now, multiple claims are those sort of class action, if I can use the kind of American sort of litigation terminology there. And they're those claims that are being brought, mass claimants bringing claims against one employer. So typically, we've got lots of claims at the moment going through in the retail sector, particularly against supermarkets for equal pay predominantly. So they're the sorts of cases. So there is an increase in the single claims, and that's probably what most of you are going to be focusing on within your own organizations. And again, we've seen discrimination cases as well. They're still, being very prominent in terms of the types of claims that are being brought. And obviously with discrimination claims, we have that added issue around compensation where, we don't have those sort of statutory caps that we see, particularly in unfair dismissal as well. So that's going to have an impact. The backlog of cases is going to have an impact on how you manage claims internally. Obviously, what that means in terms of, witness availability, evidence availability. And I think really, Peter, what we've seen in terms of the statistics, particularly around the backlog of cases, I think it's safe to say that in terms of the cases that we're managing for our clients, that's a pretty good sort of snapshot in terms of where we are as well in terms of case management, would you say?
Yeah, I totally agree, Emma, indeed. Yes.
Yeah. So we're seeing cases, aren't we, that are being listed, 2024. Have we got any advance on that?
We do. I mean, we're seeing it from both sides. There's some claims that are actually issued and then the employer doesn't find out about it for a very long time. So it sort of jumps out of the woodwork many months after the employee has left. And again, that's due to a backlog. And then again, yes, as you say, the backlog is causing some cases to be listed way in advance. And depending on the length of the trial that's needed, so how complicated a matter is, again, it really pushes it into the long grass because it's when the tribunal has availability for a longer listing.
No, absolutely. And so kind of against that backdrop, when we talk about employment tribunal claims, I think it's one of those where, we sort of say, oh, it's a personal development opportunity, but they are serious. They are serious for businesses when they are brought. I think it's really important to remember that we can't stop people bringing claims. Individuals are able to bring claims against their employer whilst they are still employed, and also, once they have left employment. They can be costly in terms of your time, your HR time, your management time, legal time. They can be costly in terms of the physical costs, in terms of compensation, etc., but also reputation as well. So we can't forget the importance of the Employment Tribunal system. So the Employment Tribunal is a court. It's just a special kind of court that sort of sits within the Ministry of Justice. And also it's important to remember, and I think to sort of remind managers that sometimes there is no magic checkbook. And so it's, vital that we think about how we manage claims, and also how we take that proactive approach with regards to, our getting our processes right, our policies right, our training of our managers, having that sort of proactive approach so that we can stop claims coming through or receiving claims. But as I said, we can do all we can, and we can be as reasonable as we can be, reasonable as we are, but individuals will still bring claims. So how does the whole sort of process work? And I think when we think about how this all sort of starts, most employers will know or have an inkling that a particular individual is disgruntled enough. They've not been satisfied with an internal grievance or an internal appeal procedure. So we will get a sense of where we're going to potentially have issues moving forward. But the way the process starts off is ACAS. So ACAS will get involved, and ACAS will contact the employer, and that process is known as early conciliation. So Peter, can you give us a bit of a kind of a feel for what early conciliation is and what it's there to achieve?
Yeah, indeed. So as you just said, it's ACAS, which is, for those of you, I'm sure you all know, but Arbitration, Conciliation, Advisory Service. And as the title says, ACAS are there to try and assist the parties where possible to reach an amicable settlement and to avoid the need to go for tribunal hearings. Now, in order to engage that process, the claimant first has to contact ACAS and then provide them with their details of the employer, but most importantly, why they are disgruntled or what their grievance is, and what it is they're looking for as a suitable resolution. In many cases, it's compensation, but there's also options for reinstatement, for re-engagement, and I've even seen cases where people just want an apology from the employer, so they just want their sense of justice. But however they choose to do that, they go to ACAS. And then ACAS will contact the employer. It's a pretty standard email that they send out to all employers in all cases, just to say that they've been engaged and to give details of the conciliator's name and their contact details. And then usually after, they will contact you directly, so not a standard email. It can either be an email or a phone call, but they're set out in particular why the claimant is feeling disgruntled and again, what they're looking for. And it's really good opportunity for us as an employer, if we're defending a claim, to go away, take that information and start really considering what has gone wrong, whether there's any merit to what the claimant is alleging, and how we would also like to see that settled. In some cases, yes, we're happy to settle. We might say, look, we've done wrong, or we might say commercially, it's the best way to move forward. Other cases could be a policy decision where we say, no, we're not going to settle this. But it is a really good opportunity to make those considerations and start to set yourself up for what's potentially to come. Now,
absolutely.
Sorry, go on.
And I think that was why early conciliation was brought in, wasn't it? So it was brought in basically to stop claims from going through the full process. So you're absolutely right. It is that opportunity to be able to, you know, have a first review. And as you said, you know, we call it the merits. So what are the merits of the case? Is this something that the employer wants to proceed with? And also, you know, don't forget the employer can also contact ACAS if they so wish and say, look, this is what's happened. We would actually like to engage in a dialogue with the employee and try and sort of reach a sort of settlement as well. So it can be useful for employers to engage in that process as well. I think really sort of a top tip here would be around making sure managers know that if they do get an email, I know we say, you know, the employer will get an email. Well, you know, obviously in very large organizations, you know, it could be one that the email comes through to a manager and they may not realize, because that's not the, you know, the claimant has to give the name of a contact within the organization. It may not be the HR manager, HRBP, or the HR director. So I think it's making managers aware, because the time limits are so tight in this, which we'll come on to talk about. So again, making sure you've got those processes internally, that if ACAS do contact a manager or, you know, someone within the business, they know how to escalate that. So I think that'd be a really important thing. And why early conciliation is necessary is because the claimant cannot move forward with their claim. So they can't issue an ET1, which is the claim form, until they've got an early conciliation reference number, a certificate. So if the claim settles within that period of time, and there's a 6 week window, so if it settles within that time, brilliant. ACAS will sort out, you know, the settlement for that, and that can all be dealt with. If the case doesn't settle, then the claimant will need that certificate number, because if they don't get it, they can't proceed. The other reason why the ACAS process is important is to do with what we call stop the clock. So as you all know, those listening, in employment tribunal disputes, there is a time limit within which individuals can bring claims against the employer. And that can sometimes vary depending on the nature of the claim. But for the most part, it's 3 months. So it's 3 months from either the date of termination, or in discrimination, it may be the last act that somebody says is of less favourable treatment. So we sort of work on that 3 month window. The early conciliation process is mandatory in most cases. So the employee contacts ACAS, and then effectively that 3 month clock stops. So stop the clock. And then there is this period of up to 6 weeks, which can be extended if the parties are nearly close. And then once if the case settles, fantastic. If it doesn't, then the clock will restart, and then, you know, the remaining period of that 3 month window will then continue to run. And that's important when we think about evidence, when we think about data protection, when we think about keeping records, because, you know, some people may have policies where things are destroyed, perhaps, you know, 3 months after somebody leaves, but potentially you've got a longer period of time when documents, evidence, etc. may be relevant. So think about that when you're thinking about, you know, how you're going to preserve evidence.
And that's something I was just going to say, actually, Emma, as another tip. When you do receive ACAS notification, you can also use it as a bit of a trigger moment. So, for example, Joe Bloggs could have handed his resignation in and left, and we believe he's just leaving and moving on. You hand his laptop into IT and say, look, wipe that, get it ready for the next person, etc. And then suddenly you get hit with an ACAS early conciliation notification. So it should be a really good trigger that, you know, you need to retrieve that, and you need to start preserving evidence that you may otherwise have inadvertently destroyed, because that could be extremely useful for you in defending your claim, and for assisting the managers, etc., who need to start compiling the information. Absolutely,
yeah, that sort of need to sort of churn, particularly IT, you know, might send it could actually sort of come back to bite us if things have gone. A claimant will always have a minimum of a month at the end of the early conciliation period. So, for example, if somebody doesn't get, into gear and doesn't contact ACAS until right at the very, very end of their limitation period, obviously the clock will still stop. Even if there's a couple of weeks still to run, they will get a minimum of a month. So early conciliation is important. It's one of those first periods where obviously you can engage with the process and really kind of start getting your house in order. So obviously, let's say, for example, the claim doesn't settle, the claimant gets their early conciliation number, they get their certificate, and they file an ET1 form online. And that's really their opportunity to say, this is what I'm seeking, this is the claims that I'm wishing to bring. And it is as simple as kind of a tick box exercise. They give a little bit of information about why they say what the employer has done is wrong in their opinion, and also what they're looking for. So as Peter said, are they looking for money, compensation? Are they looking for reinstatement, re-engagement? So that's it. And so then you will receive that form online, and then we sort of go into process mode, don't we, Peter? And then we have that that point where we need to file a defence. And what's the time limit for that? Because it's quite tight, isn't it?
Yes, it is 28 days, but rather helpfully, the tribunal, when sending out the notice of the claim, they do set out the deadline for filing. So take note of that, diarise, and obviously ensure you keep in time with that.
Yeah. And is that one where we're getting that online, or is that old-fashioned paper?
The ones I'm seeing are all online, but there are occasions many occasions in paper. It depends on what the claimant puts on the claim form. If they give a contact email address for the respondent, then you may well see it online, but otherwise the tribunal have to send it by post using the details.
And I think that's the point that we tend to sort of get involved, don't we, sort of drafting that defence. So we're going to be really kind of, drilling down what's being claimed, why is the claimant raising this, what issues. And again, so that's another opportunity for us as lawyers to really look at that claim and really help clients assess where we are, what are the merits again, is this something we want to do, is this something we want to put in a holding defence, so we've got an opportunity then to sort of, put things in detail. So the ET3 is another really good opportunity to be able to review kind of what's going on. Okay, so we've got a question in. Peter said, we're live, so do, ask questions and we'll do our best to help you. Questions come in about what happens if we don't meet the 28-day deadline.
Indeed, okay.
We've had that, we have had that.
Yeah. So the automatic default position is that you're in breach of the tribunal order, and as such, judgment is automatically entered against you. Now, what that means is it doesn't completely exclude you from the tribunal process, but it does preclude you from being able to argue on the merits of the case. So in essence, it would then proceed mainly on issues of quantum. Now, if you do file one late, and it does happen, and there could be a range of reasons as to why it happens, there are remedies for you, and that basically is to make an application to the tribunal, setting out why you why you were late, and give a good reason if you can. So, for example, you could say, well, you sent it to the wrong address, or the email address you sent it to, that person is no longer with the business. But do set out your reasons, set out why you're saying it would be just and equitable for you to carry on, and why it wasn't, if necessary, why it wasn't reasonably practicable for you to file it in time. And a tip here that I would always say, when filing an application to serve your ET3 outside of the time limit, I would actually serve a copy of your ET3 with it. And I find that in those cases, what the tribunal will say is, well, we've received the application, we've considered the reasons as to why it was filed late, and now we have the ET3 in any event, which we've had a chance to consider. So I would say make the application, but always file your ET3 with it. I
think we've had an issue around kind of data protection. I think you're probably thinking about subject access requests there. That's a separate process that's under data protection laws and not under the sort of strict litigation process. We will talk a little bit about SARS when bit later on, so I'll cover that. I'll cover that later, but thank you very much for the question. So I think the main thing is if you can, please don't leave it to day 25, because it just makes it so much more difficult for us to be able to do our job, which is to support you in putting forward the best case that we can do. But, you know, we are aware that things happen, particularly when things are sent to the wrong office, the wrong people, the wrong manager. They don't know what they've received. So it's all about getting people aware, making them aware that if you get something, you need to escalate it. You need to sort of raise it higher and with HR. So, you know, if we've got that defense in, then sort of the process becomes a little bit mechanical. And what we tend to find is we then get directions. And directions is really, you know, how are we all going to get to the end point, which is a hearing date. And it's a timetable. Sometimes they might be issued automatically by the tribunal. Sometimes there may be particularly more kind of complicated cases where there's, you know, greater witness evidence and things like that. There might be a directions hearing, usually by telephone, where the parties can say, okay, well, we're going to have 5 witnesses. We're going to need, you know, 2 months or 3 months to be able to get our witness statements together. So we want to exchange, you know, in 2 or 3 months' time. So it's more about kind of, you know, how are we going to kind of organize everything? When are we going to exchange documents? And again, those milestone dates, which is really important, that obviously the business engages with that to make sure that we get the information so that we can then obviously comply with what's going on. Sometimes, as well as directions, there may be what's called a preliminary hearing. Peter, what's a preliminary hearing and what sorts of cases might we find one?
Yeah, so a preliminary hearing is basically the tribunal's way of having a case management conference, and that's their way of bringing the parties together so they can discuss a wide range of issues that may exist in a case for case management purposes. So typically they could be used for things such as determining issues in dispute between the parties, and they would be issues that need determining prior to the final hearing. So for example, if a claim's been issued in time, you could determine that at a preliminary hearing. If the case is not, or is deemed not to have been issued in time, then obviously the case would stop there. And that saves a lot of time, effort and cost for everyone involved, not least the tribunal. But again, if it is issued in time, then you know that you're okay to proceed and go on to a final hearing. Another reason could be to determine the issues in dispute between the parties. So Joe Bloggs could issue a case against the employer saying, I have been discriminated against, but not give too great a detail on that. So the tribunal might say, well, is this direct discrimination? Is it indirect discrimination? Who are you alleging discriminated against you? And ultimately that can even lead to a list of issues being prepared. So there are lots of reasons and needs for a preliminary hearing. But as I say, essentially it's a case management tool of the tribunal. And it's also very handy for the parties because it does give you that better understanding of what the other side's case is. And again, helps you to prepare for the final hearing.
Thank you. So as I tell all my attendees at my training events, we love evidence and we love paper, because obviously if we don't know what's gone on, we can't advise and we can't give you the best support that we can give and give, you know, our clients, you know, the best service that we can. So we need evidence. And it's always better to get evidence early. So again, we can assess and help you move forward. Now, often what we find, and we find quite happens quite regularly, is that a potential claimant, so remember, claimant is the individual who's bringing the claim against you, respondent is the employer. And also in discrimination cases, it may also be a named individual as well, so, you know, the respondent. What happens is that before all of this happens, you may find yourself receiving what we call a subject access request, a SAR, DSAR, Data Subject Access Request under the Data Protection Act. And really that is, we are finding it happen more and more regularly, and where we are getting requests from potential claimants really just to have a look at and maybe what documents we've got. For example, what's written in a personnel file, what emails maybe have bounced, particularly between kind of managers. Is there any sort of written evidence? Sometimes it can be used as that, as that sort of fishing expedition as well. Now, the rules relating to what documents we need to disclose in a subject access request are different to the rules of litigation. So the rules of litigation are, much, much wider. The powers of the court with regards to documents they can order for disclosure are huge. Whereas with subject access requests, there are certain exemptions to documents under the Data Protection Act. But often, yes, you will find individuals will want to do that, and then you've got your 30 days with which to provide individuals with either a description of the documents that you're holding or documents that you are able to disclose. So subject access request is kind of, again, a bit of a sort of hang on a minute, alarm bell. We think maybe there is something that's going to happen, and we think maybe there's going to be a tribunal claim. But subject access requests and disclosure are not the same, So, the next stage really is around disclosure. So what is it? What evidence do we need? And that's, again, going to depend on the case itself. CCTV evidence? Is it going to be performance reviews? Is it going to be appraisals? Is it going to be party-to-party emails, letters, meeting notes, disciplinary records, redundancy, selection criteria? So again, it will depend, but really we are looking for the good and the bad. What we don't want is, confirmation bias. We want to see everything, the really bad stuff, as well as the really good stuff, because then we can make an assessment. Because what we don't want is, we don't want anything to surprise us or you, or more particularly the court. So again, there may be some exceptions, particularly around that without prejudice conversations, and particularly around lawyer conversations where we are providing advice to you. Copying your lawyer into every email is not legal professional privilege, and legal professional privilege cannot be retrospective as well. We'll talk a little bit about sort of disclosure in a moment, but the next stage is obviously your witness statement if you are called to be a witness. So, that's possibly going to be the manager, the decision maker, the HR manager. So, maybe colleagues as well, if allegations have been brought about, issues that have happened within a team. But really what is important to think about with a witness statement is it is your evidence, it is your voice. And so even though you may have assistants drafting it, so often we may ask a potential witness to sort of, draft a sort of a skeleton about what happened, what they want to say, and we may polish it up. It is important that you're happy with it, is your evidence. Now, it's very unlikely you'll be asked to read that statement out, but you will be asked to confirm if we do get to the sort of tribunal stage, that is your evidence, and you kind of stand by what you say. So it is important that you engage, if you are a witness, with the litigation process. And then, if we get through our directions and we've exchanged our witness statements and all our documents, and we haven't been able to settle, because don't forget, we can settle at any stage during this time, even at the court door or during the hearing, and ACAS can be involved in that, or we can liaise directly with either the individual or their representative. But then we get to the hearing, don't we, Peter? And any tips, any experiences there, any help you can give us on the hearing?
On the final hearing itself?
Yeah,
indeed. So again, as we've been sort of saying and repeating ourselves again and again, it's really key to be prepared for the hearing. So on our part, for the respondent, obviously there will be a trial bundle and there will be witness statements. A key tip there for the witnesses is to read their statements, reread their statements, and reread them. And that's really simply so that they're completely familiar with what happened, and what they're saying about what happened. And I say to read and reread, because usually it's the case, an event that happened 12 months ago, maybe longer. And this could be for a manager that, has 20 or 30 people reporting into them. They've got lots of issues going on. And to remember what happened 12 months later with one individual employee can be difficult. So, make sure that they're familiar with their evidence. And then that way, when they get to trial and they're asked questions on it, they're able to give good, reasoned answers as to why something did or did not happen. And so they can, persuade the tribunal that what they're saying is correct and what they did was right. So.
And what are we finding now? Obviously there was a bit of a sort of change, obviously, sort of during the lockdown. So we went from obviously in-person hearings to kind of remote. What are you finding now in terms of how things are being, structured with regards to sort of these final hearings?
In the main, I'm finding that the hearings are still being heard remotely, which is by way of CVP, which is basically the tribunal's version of Teams or Zoom. And I find they are being heard by CVP, and that's for a variety of reasons. It could be that the claimant lives in one town and they was commuting far away to work, and the respondent's in another town, so it's just easier for bringing people together. It's also because, as we said right at the start, the tribunal are backlogged. So I have some claims that are issued in, let's say, the Watford Tribunal, but the final hearing will be in the Bristol Tribunal. So again, it could be a case of the judge is nowhere local to the party. So predominantly, I'm finding their CVP, although I do have some in-persons coming up. It really is case specific, I guess.
Yeah, and how has that switched into virtual hearings and virtual bundles and that sort of thing?
It was fun at the start. So remote hearings have always been a possibility. The lockdowns happened, and then suddenly they were a must. I find personally they're okay. I find for the claimants, they're often a bit more difficult. So, for example, we work for Boyce Turner, and we're very lucky. We have numerous screens and we have access to all the papers. I do find that in some hearings, you'll have a claimant who is using, in cases, literally their mobile telephone as their sole device. So that's for them to be able to see the proceedings, to answer questions and to talk. But also they use that to then flip through the bundle. And depending on the case, it's a 500-page bundle and someone says, well, please flip to page 310. You'll see their finger on the screen flicking and they're trying to work, and it really delays things. And it does put them at a slight disadvantage, not that that's anyone's fault. But even when they have a laptop, it's usually a laptop, and they don't have the access to the devices we do. So it does put them at a slight disadvantage, and it can delay things slightly. But in the whole, I find CVP does work, and it's an effective way of hearing the hearing.
That's a really interesting point, and I hadn't thought about that. And I suppose when the employment court was set up, it was known as the Industrial Tribunal, and the whole point of it was it was this informal court or informal kind of resolution method where employers and employees could come together before a judge and basically air their grievances. So you didn't need necessarily a lawyer, or you didn't need wadges of paper. And now it's become so tech, and the law is complicated, and being able to represent yourself. It's very interesting, isn't it, how that whole kind of access to justice piece has changed so much. But anyway, that's just me kind of musing, and it's interesting what you say about people having to access things on their mobile phone, or not having access to up-to-date technology and mobile phones. Thinking about the kind of demographic of people bringing claims, age claims, race claims, sex claims. It's just it's very interesting how that access to justice piece works now with kind of virtual hearings. But there we are. We've got that sort of hybrid at the moment, and everyone will give their evidence. Witnesses will give their evidence. You'll refer to documents in a bundle, whether that be a kind of lever arch file or an online bundle. And again, it's important when you read your witness statement to also be familiar with the documents, because it might be that I had a meeting with them, and at that meeting we discussed possibilities for suitable alternative employment. So you'll be asked to go to the document just to make sure that you've got that sort of cross-referencing. So as well as your statement, make sure you know all the documents as well. And then there's that opportunity then to cross-examination, whether that's somebody cross-examining you or your representative cross-examining, obviously, the other side. And then we have that opportunity there to kind of re-examine, which is if there's been any issues that have come up in cross-examination that need to be, kind of defined or revisited, then again, that's that opportunity. It's not an opportunity to ask new questions or think, oh goodness, I forgot to ask that. It has to be based on the cross-examination. And then the judgment, which can again be given orally, so maybe there's an adjournment, but what we tend to find is that just because of the throughput of cases, you may find that the judgment hearing is put to another date, or you tend to get your decisions in writing, and that tends to be what happens. So thinking about kind of the process and how it all works from, early conciliation to, final judgment, let's have a little think about now using our sort of experience where those do's and don'ts are. And I think the first one, Peter, and we were kind of talking about this, is this kind of engagement piece. We need managers, we need HR, we need individuals to engage with the process. And also to know what to expect, I think, know their role with all of this, know the expectations around kind of witness evidence, disclosure, around being at tribunal. One of our biggest issues is around witnesses not necessarily realising that they're going to have to sit in a court or online for a period of time. Don't we, Peter? We find that particularly when we've got clients who've got witnesses in other jurisdictions.
Yeah, indeed. And as you say, it's just engaging and making sure that everyone is aware as to what is expected of them. And there's, you can do that by speaking with HR and they can give you a good update. Whenever we take a case to trial, we always make a point of having a call with the witnesses in advance to answer all their questions, to let them know what is expected of them, what the tribunal will look like, etc. But it really is preparation.
And please, if you are called to be a witness, manage your diary, because once that hearing is set, it's very unlikely that we are going to be able to get that moved. So if you are not going to be in the country, if you are not going to be, if you're on holiday, that diary needs to be completely clear for the whole duration of the employment tribunal. We will do our best to manage, but where it really is incredibly difficult is if a key witness says, oh, I'm on holiday, or I've actually got a meeting that day and it can't be moved. So, we have to have engagement with the actual, as Peter said, those expectations. So do engage. It is important for all the reasons that we've talked about. I think our first don't is don't close ranks. And what do we mean by this? Tribunals are important. Tribunals do have that kind of, air of the unexpected. We can give you our kind of best case, worst case, but it is very much how things happen on the day or the week or however long the case is for. But also, things do go wrong within businesses. Sometimes we do make the wrong call, we make wrong decisions. And I think there's that sometimes everybody goes into that kind of defense mode. It wasn't me, I didn't do it, I didn't make the decision, HR told me to do it, I was just doing what I was, that somebody else did. And I think, sometimes you do have to kind of sort of, say, look, okay, this wasn't great. We could have done things better. Now, whether that makes the claimant successful is another thing. It depends on whether, what you did or didn't do, the impact that had on the decision or the process or whatever it might be. So there are learning things, aren't there, from all of this. But I think this point about, not closing ranks, sometimes we do have to sort of learn lessons from the process as well. Disclosure, I mean, this is a huge one, isn't it, Peter, for us? What are our do's and our don'ts around disclosure?
Indeed, yeah. So, I mean, the ultimate duty upon us is to disclose anything that is relevant for the fair disposal of the proceedings. And that includes documents that either harm or hinder your case. So again, going back to what I said earlier, as soon as you realise ACAS have made contact and there's the possibility of a claim, you have a duty to start preserving evidence. You can reach out to your managers or whoever is involved in the case and say to them, look, Joe Bloggs has raised an issue. make sure you keep hold of things. And also start getting those managers to start compiling what they have at that early stage. Because one, it allows you to sort of fully understand the case. There's always two sides to a story. But it does then start, giving you the forerun on that, so you're prepared for when disclosure comes up. And disclosure, it refers to documents. And I think many people think of documents as physically, a book or an email. But a document can be a WhatsApp message. It can be a piece of CCTV footage. It could be a voice recording of a grievance meeting. Anything that contains evidence within it is potentially disclosable. So, just keep that in mind when considering what you need to put forward.
Exactly. That good and bad, and making sure, that you've got email trails, that you haven't got emails that are missing, that have been forwarded, missing them within the because all of these things will be linked up. And don't forget, the court doesn't know you, doesn't know your business at all. All it will see is a bundle of documents, and it will hear from you as a witness. So it's about creating that, creating that image, that impression, of an employer that's tried to do the right thing, and that, again, that really is important when we think about how we behave at tribunal, whether that is in person or whether that is online. The Employment Tribunal is a court. We don't wear wigs and we don't wear gowns, but it's still a place of respect and a place of law. And we come to law, with, we would say, with kind of clean hands. So it's really important that, when you are, either you're joining online or you're walking into the courtroom, you are on show from the moment you step into that courtroom. So if you're a witness, you're sitting behind your representative. So again, making sure you're not coming like loads of bags or coats or, it's just simple things. It's simple etiquette, because you will be watched, and also you'll be watched about how you respond. So if somebody is giving evidence, if you're huffing and puffing and folding your arms or constantly writing post-it notes and handing it to your representative, that's, again, it's about the impression that you create. Peter, I know it's the same with online hearings as well. So you'll have a virtual gallery, won't you, as well as people joining. What are your kind of issues and tips around that?
Yeah, again, it's as you say, even if it's online, do remember it is a tribunal hearing. So I always say to people, forget that it's online, pretend you're there in person. So I always say dress appropriately, just show some respect to the tribunal. The tribunal are wise to the world and understand that if you're working from home or attending from home, there may be children in the background, dogs, deliveries, etc. But try and work around that. And if you do have to stop to answer the door, then do so. The tribunal is very forgiving, but what you don't want to be doing is constantly having to disrupt the proceedings because you're constantly having to do things, because the tribunal won't have much truck with that. And they have to judge the case on its merits and on the facts, but equally they're not going to like a disruptive claimant or disruptive witness. So
yeah, absolutely. And I think this whole point about not laughing and joking, be careful, and we don't want slogan t-shirts and things like that. We don't want, because you are your camera is on all the time. So again, and I think looking disinterested, somebody's brought a claim. Sometimes it's a real effort for somebody to have brought a claim. They may have invested money themselves. So again, we have to respect, even if we don't think that they've got a chance of winning, we have to respect their right to be able to bring a claim, to have this access to justice. And again, the Employment Tribunal is a special place. You will have a judge. You may well have wing members as well. So again, remembering it does have that court feel as well. So being a witness, and I know people get terribly nervous about being a witness. What are your kind of tips around being a witness, Peter?
Yeah, so I always say to the witnesses, all the tribunal is there to do is to determine what happened and whether a wrong was committed or not. So I always say, give your evidence, truthfully, not that I suspect that they would lie, but give your evidence truthfully. And even if you think that you're going to give an answer which may potentially cause a problem or shoot your employer in the foot, it's kind of irrelevant. You know, if that is what happened, then you need to say it. And all you will do by giving the true and correct answer is you will assist the tribunal in determining the issues in dispute. And in most cases, it will show to the tribunal that you're an honest witness. It will show that your employer or the defendant does act with good intentions, and yes, potentially a mistake's been made. But they can look at that and determine whether that mistake is enough in order to justify the claim that's been issued. And very importantly for the employer, if a mistake's been made, well, they can learn from that. And that's how we learn best often, from our mistakes. So I always say to witnesses, you know, as well as you have to be professional and show etiquette, just be honest and open. You can only give the evidence that you're able to give. And if you provide that to the tribunal, then they will take that as your evidence and rule upon it accordingly. So,
and always listen to the question. Don't try and give the answer that you think the representative wants to hear.
And I'd also say another one is always answer the question you've been asked. Quite often a barrister will ask a question, or maybe even the judge, and the witness will go into a big long ramble as to what happened and why and how and when, but you didn't actually answer the question. And sometimes you end up giving away more than you intended to, and you might throw them a bone that they needed, so to speak. So to really listen to what has been asked and answer that question.
Yeah, don't be obtrusive, but if yes and no suffice, then you know, keep it short.
Yeah.
But again, you know, I think there's that tendency, isn't there, you know, to be you know, to sort of try and be more helpful to in those situations. And you know, I think the last one is really, you know, don't argue. And it just at first it just looks awful, but you know, sometimes, you know, the opposition's barrister or solicitor or the claimant, because don't forget, claimants don't have to have legal representation. They could actually represent themselves, and also they don't need a lawyer. They could bring a friend or someone to help them. But you know, don't argue. Basically, if you can disagree, absolutely, and that's your job, is to if somebody is telling you something that you disagree with, and say, no, I think you're wrong. If there's evidence that you've got there that can support that, you know, going back through the bundle. But it's this sort of, you know, you tread that fine line between obviously being firm about what you did and didn't do, accepting where things could have been better. And as Peter said, if things have gone wrong, it doesn't necessarily mean that you're going to get a huge, massive, you know, compensation claim, but also making sure that you're not arguing. You know, sometimes the aim will be to rattle a witness, particularly if you've got an allegation there of behaviour, of you know, conflict within a team. You know, let's get the manager wound up, and we'll see, you know, kind of how they, you know, this is what I'm talking about. So don't argue.
No, and I'll also add to that, just always mind your language, and I don't mean in the sense of swearing, but I had a rather odd case a couple of years ago where there was a discrimination claim, and then the witness kept saying, well, that woman, and that woman, and that woman, and it just sort of stunk of discrimination, as if he didn't like women for some reason. So, and I'm sure he didn't, but I think it's just his language. He referred to as that woman, probably because he was quite angry with her. So do mind your language, because as well as arguing, you can just come across as offensive, or, you know, play into their hands, which you don't want to do.
I think sometimes I found actually it's quite nice sometimes when the employer's witnesses actually call the claimant by their name. Sometimes it's quite awkward, isn't it, when you have to call somebody Mr. this or Mrs. that, because we're not used to doing it. You know, again, it's about, you know, sometimes actually agreeing that you're going to just sort of call people by their first names, kind of makes it more natural, and makes it, you know, that sort of way that it is a kind of a conversation. Because, you know, at the end of the day, you're trying to get to a kind of, you know, what happened. Is there a kind of a line between, you know, what's happened and who said what? And that's really what the tribunal, as you've said, Peter, is there to do. So what can we say about the process? Well, you know, there is an opportunity to stop it it's not like a snowball coming towards you. As Peter said, there may be those opportunities where actually you think, do you know what, as a business, we are going to defend this because we did try to get it right. I would avoid cases being brought on the point of principle. Principles can sometimes be quite costly, but there are those opportunities to settle either through ACAS or via party-to-party correspondence. But take it seriously. There are commercial decisions that are sometimes made in these types of cases. It is your opportunity to put your side across. It's not always the case that, and sometimes businesses don't want to get into magic checkbook mode. There might come a point where you actually, do you know what, we're going to go to tribunal because, we want what we've done to be heard and to be judged. And if we have got things wrong, then we will make changes because, it's a learning opportunity. As I said, it takes courage to bring a claim. So be respectful of another's view and their right to bring it. But be proactive. What's our training like? We want to stop these claims. Do we have manager training? Do we have HR training? What are we offering in terms of how do we manage disciplinaries? How do we manage performance improvement plans? What's our awareness like across the business, particularly when we think about discrimination, harassment cases? Do we have a kind of a program of equal opportunities training, particularly that legal training? Legal opportunities training for managers is an absolute must. Can't stress it to employers enough. It's an absolute must. And again, having those positive conversations, isn't it? Are we that destination employer? Do we have those open door policies? And, Peter, what can we do to help if clients do get claims? If we've got people listening, we've got numbers of people on the call today, how can we help? What can we do?
Yeah, so, we can help with anything right from the outset. So it's the second bullet point. It says ACAS assistance. But from the word go, I've had cases where people come to me and say, look, I've been contacted by ACAS. The person is alleging this, and what do we do? So we can actually jump in then and we can liaise with ACAS for you. I've done that numerous times. And on many occasions, it's never gone further than ACAS because once it's been explained to the claimant via ACAS, as this is what actually happened, despite your view, sometimes it doesn't go any further. We can offer full litigation service. So you might say, look, we'll give you the papers. Can you handle the claim for us? There's cases where we just give assistance, where you might say, look, we want to handle it, but we'll ask you to help us drafting the witness statements, or would you help us just reviewing the schedules of losses? Which leads on nicely to the next point, reviews of quantum and compensation. Claimants are often very
creative.
Yeah, they are. They're brave with what they claim. And we can look at that and say, no, look, there's statutory caps applying to that. Or look, in reality, a claim of this nature in the tribunal would only attract, half of what you're claiming. We offer volume employment litigation support. So there are some employers out there that have quite a lot of claims made against them. Not because they're a bad employer, it's just the nature of their business. And they have disgruntled people. We can assist with settlement agreements, advocacy, basically anything. We can help you from cradle to grave, as we say, so from the very outset right to the final hearing. And then even after that, as Emma said, you may win, you may lose, but win or lose, you often learn valuable lessons. And you might say, well, we don't want this to happen again, or we'd rather improve how we handle our recruitment process. So, we can provide training and assistance and guidance. So it doesn't really have to start or end with the tribunal process, and we can provide, all and any assistance you require, really.
Thank you, it's really helpful. And SARs as well, subject access requests. If you're getting those SARs, again, we can help with those. We've got programs that we use which keep the costs down of managing those SARs internally. So get in touch with us as well. And again, I think sometimes people think it's going to be really expensive to go to a lawyer, and it may well be, but actually there are ways and means that we can make this work and still help. So, for example, clients will do the kind of the legwork in terms of document drafting, etc., and we will be the checkers. So, we can manage things. So, if those of you listening that have got claims and that, are kind of worried about how you're going to manage it, just get in touch, even if it's just for us to review it and give you a few pointers and a few steers. So get in touch. So this is us. I'll send you out some information so you can get in touch with us. But if you've got, cases that you want us to have a look at, then get in touch with Peter. We've had some fantastic wins recently. Peter's had some fantastic wins for clients recently. So it's really great that he's been able to join me today and kind of, share his tips and his experiences around the Employment Tribunal process. I'll be sending out a link to this. So again, you can watch it, share it at your leisure, catch up with our YouTube channel as well. We've got all our previous webinars on there as well. So check them out, get in touch if we can help at all. Really hope you can book onto our courses. So 10th of May, put that date in your diary, 90 minutes virtual. What else are you going to be doing between 9:30 and 11 in the morning? Let's get some tips and techniques to really kind of boost that productivity. Remember, boost engagement, boost your mindset, productivity, engagement, all those fantastic things. Let's start that day positively. And again, HR, if you're in HR, new to HR, you've got somebody joining your team, the masterclass is for you. So again, looking forward to seeing many of you on that as well. So my thanks, Peter. Thank you, Peter, so much for joining me.
My pleasure. And thank you to everyone for joining. Thank you.
It's always a weird one, isn't it? We are actually both in the office today, but in separate rooms. But that is the way. So thank you so much for joining me. And again, thank you to the massive numbers of people that we've got joining us. It really is appreciated. So again, give us your feedback. What do you want to hear about? And we will plan our program accordingly. So enjoy the rest of your day. And again, thank you very much. See you all next month for next month's webinar, if not before. Bye-bye.